Hello America! In this video, just as in the last video, I'm cramming in a lot of information. So to get it all in, I'm putting up on the screen various sections of the United States Code, and they will only remain up there for about 5 seconds. I highly recommend that you pause the video to read the code and then hit play to proceed through. Today I'm going to share with you some insights on ERISA as it pertains to fiduciary advisors and managers. Then I'll give you 8 questions you need to ask prospective candidate advisors and managers. But first, here are some quick housekeeping notes. First, I am not an ERISA attorney, and I am not giving specific advice on your situation. However, I have been in the retirement plan business for over 25 years now, and I am an accredited investment fiduciary analyst through the Center for Fiduciary Studies out of the Joseph M. Katz School of Business at the University of Pittsburgh. So I have to know the law since I work within its constraints every day in our practice. Finally, all of the sections of ERISA that I refer to in this video are on our website. Just click on the links button at the upper right and it'll take you right to those links on the United States Printing Office website. Back in August of 1974, when ERISA became law, there were a lot of issues that needed to be tackled. Prior to the finalization of the bill signed by Gerald Ford, a lot focused on who would be responsible for the selection and oversight of the investments used within any tax-qualified plan. No doubt there were many hearings on this. But as for the fiduciary responsibility section, it all became part of the United States Code on September 2, 1974, and all of it is in plain English, direct, and really can't be misinterpreted. So I can't say for sure if the department wants you to hire an investment fiduciary, but it seems awfully apparent that plan sponsors were wanting some kind of help here, and the DOL wisely listened and understood that it would be more prudent to allow plan sponsors to hire prudent experts, and they came up with some great regulations. Let's take a look at some of them. First, ERISA 402C 2 and 3, which are quite clear. And to support that section, here is ERISA 405D1, the independent fiduciary section. So right here, ERISA is being very clear. You can transfer your responsibility with regard to investment selection and oversight to an external party, an investment manager, but not just any advisor or manager. Let's take a look at the definitions section of ERISA to see what it says. Here we have 2 specific sections to review. First, ERISA 321A2, and then ERISA 338. What 321A2 means to you as a plan sponsor is this. You are still responsible for the selection and oversight of fund options on the plan's menu. You are also responsible for overseeing the due diligence, the process of the oversight. Don't think for a minute that the advisor acting under 321A2 is responsible for that. He is only responsible for his advice being based on sound principles, whether the advice is good or not. And at the participant level, even though you may hire a 321A2 fiduciary advisor, you still need to seek 404C relief, which, as I wrote in this very article back in March of 1994, there are 23 hurdles you need to successfully reach before obtaining such relief. The fact is, just as Fred Reich, a very famous ERISA attorney, has said in his speeches since 2005, I've never seen a plan that was 100% compliant with Rule 404C, 24/7, 365. And he's right. So the gist of it is this. If you hire a fiduciary advisor, your work isn't done, and in fact your work just increased because you have to go behind your fiduciary advisor to make sure his advice is any good. The fact is, I have yet to see any 401k plan sponsor do this. Well, what about the 338 fiduciary investment manager? This is a completely different situation from the 321A2 advisor. The 338 manager assumes full responsibility for the selection, oversight, and disposition of the investments used within a plan, and this can be translated down to the participant level as well. With a 338 manager, you do not necessarily have to comply with 404C. That's the role of the 338 fiduciary investment manager. The 338 manager has the discretion, not you. So the gist of it is this: if you hire a fiduciary manager to your plan, the only thing you need to do is to make an effort at documenting that the manager is using established prudent practices in his or her selection and oversight throughout his or her tenure as your fiduciary investment manager. You don't even have to know how these principles work. Just knowing that they are in place and activated anytime he or she exercises their discretionary authority is sufficient. This means then that your workload just got a whole lot lighter with an ERISA 338 manager. But here are some roadblocks to hiring a manager. First, you've got to find somebody that will take on such a challenge. At last count, there may be 25 or 50 ERISA 338 investment managers in the entire United States. Another issue is that if you're going to be an ERISA 338 fiduciary investment manager, you'd better have ERISA fiduciary liability insurance that specifically states that the insured is covered regarding ERISA-based plans. I'm not talking about errors and omissions insurance that brokers, bankers, and agents carry. In fact, I've read several E&O policies, and the language regarding coverage of ERISA-based plans is often contradictory and vague. Now let's discuss the ERISA co-fiduciary, and I'm sure you've heard of this in the last few years. This clever gimmick is actually a misuse of the term. When record keepers or brokers hold themselves out as the co-fiduciary, there's a discrepancy between the law, what they are misrepresenting, and what you are thinking they are. You're probably thinking that a co-fiduciary will stand alongside you in the event of some claim against you. That couldn't be further from the truth. Here's what the law says. Now, that sounds nothing like the representation that these 321A2 advisors are claiming. You must ask yourselves what is going on here. The fact is, under ERISA 405A, everybody is a potential co-fiduciary because everybody has a duty to act if they see somebody else causing a breach in some form or another. There is no fiduciary liability relief, nor is there any shared responsibility with a co-fiduciary. That's the myth. If you hire an advisor that uses the term co-fiduciary, just beware. That person is trying to limit their exposure to liability. Finally, ERISA specifies that all of this has to be in writing in some kind of service agreement. And here's another little roadblock trick you need to be aware of. 321A2 advisors will use language in their service agreements that will further limit their exposure. They will use language that will misguide the reader into thinking that a transfer in fiduciary responsibility has been made, when in fact it hasn't, just by virtue of using one word over another. I can show you several examples of this tactic in our meeting. To quickly summarize the differences between 321A2 advisors and a 338 manager, here is a little spreadsheet. As you can see, hiring an ERISA advisor doesn't provide much protection for you or the company, and in fact increases your workload. Now here are 8 questions you need to ask a prospective advisor or manager. Well, I think that about does it for this video. If you have any questions, please feel free to give us a call or email us with a request to meet or talk on the phone. Thank you for your time, and I look forward to serving you and your employees.